Hi and Assalamualaikum to all of my classmates and Madam Shahila. Today, Group 2 will be presenting the topic about the site possession and insurance bonds. Group 2 consists of me, Nur Shahidatul AINNA binti Muhammad ARISAN, Nur NAZATUL FATIHAH binti Muhammad RAZALI, and Nur ZEITI ATIKAH binti Muhammad RUZAINI. So first, I'm gonna present to you the topic about site possession. So first, for the definition of this topic is according to the New Oxford Dictionary, 2nd edition. Site can be defined as a piece of land where a building was, is, or will be. While possession also can be defined as the state of having or owning something. So, based on generally standard forms of contract that commonly used, can be described the site possession as the contractors also have the right to enter the site, to occupy and to use the site, and also to carry out the specified works that have been planned before. Next, for the introduction, first, the possession of the site is access to the site for the employer, his professional team, and necessary contractors employed by the employer, which means the contractor and his professional team need to have an eligible access to enter the site construction, along with their specialist contractors assigned by the employer. Also, the ownership of the construction site means the construction site or related area is handed over to the contractor for a certain period of time. So this is also mean when the construction site has been handed over to the contractor, he is entitled to carry out whatever construction activities that has been planned before. And then, in addition to carrying out the construction activities, the contractor also need to take a full responsible for the construction site and all of the activities that need to be carried out. This is also mean that only the certain people can enter to the site, and if someone enters to the site without getting any permission first, it can be considered as an intruder and can be prosecuted. Next is the duration of possession site, which is it starts from the date of possession of site to completion date, and it is also inclusive of extended time if the contractor is granted for EOT, extension of time. This is also can be mean if the client fails to give possession of the site to the contractor and there are no provisions for delay in the contract, then they will be breached from the contract. Also, even if the contract does provide the delay in giving possession of the site to the contractor will still be able to claim for EOT, extension of time, and perhaps loss and expenses. Alright, next is contract period. Okay, contract period is mean the possession will usually provide to the contractor with such an exclusive occupation and use the site as required for constructing the work. Alright, next we go to the related clause for this topic, which is in PWD form. 203A has mentioned in clause 38 about possession of site, while in PALM Contract 2018 has mentioned in clause 21 about date of commencement, postponement, and date of completion. Okay, next is the process of possession site, which is the first is employer is obligated to give possession of site in order to allow the contractor to carry out his work. Okay, and then 5% from contract sum is secure to secure the due performance of the obligation under this contract by the contractor. And then the date of possession is stated in letter of acceptance, which is need to send to the contractor and can be as the appendix of conditions of contract in contract documents. Usually, the date of submission of the construction site is 2 weeks after the date of possession site. Why within 2 weeks? It is because to provide the opportunities for the contractor to provide the necessary preparation before starting the work on the construction site. Okay, and then the extent of possession that must be given to the contractor is not necessarily to be the whole site. This is as mentioned in clause 38 in PWD form. In addition, the employer also is not deemed to guarantee possession due to the events outside of his control. For example, the employer will not take any responsible if the contractor is prevent from gaining access by a third party, such as an unauthorized picket.
Next is delay in giving site position. This slide shows the delay of site position of client to contractor. The SO, Superintendent Officer, has the power to defer, change the giving of position of site for whatever reason, which means the Superintendent Officer has the power to give order or change the date of site position with approved reason. They will also have a notice that will be given to the contractor in writing form for contractor to analyze. There are two situations of duration not exceeding 19 days or exceeding 19 days. If delays is not exceeding 19 days based on clause 38.4, this means the Superintendent Officer will set a new date for the project. Also, the Superintendent Officer, SO, need to issue instruction to revise the date of position. Moreover, if the project is not exceeding 19 days, the contractor will not grant it for EOT, which means extension of time. The contractor also has to proceed with their works and not be entitled to any loss or damage caused by such delays. And the contractor is not entitled to terminate the contract.
I want to continue explain about the delay in giving site position. What will happen if the delay in giving position of the whole site has exceed 90 days? Refer to PWD Form 203A Clause 38.5. SO, which is Superintendent Officer, must give the written notice to the contractor to clearly inform the reason of the delay. The causes should be clearly stated, so the contractor can assess the impact that will occur to him from the delay. When the notice has been given to the contractor, he has to reply it within 14 days. The answer is consists of two options, whether the contractor wants to continue with works or he can determine his own employment. If he choose the option 1, which is want to continue with his work, he is not eligible to claim for loss and damage, as well as cannot determine his own employment. Then if he choose the option 2, which is to stop working, he is entitled to claim for loss or damage caused by the delay. What if the contractor does not give his written reply in 14 days? He is deemed to continue with his work, as well as he is considered as not taking the option to determine his employment, and also he cannot terminate his own contract. Alright, the next situation is what will happen if the delay in giving possession of the part of site exceed 19 days. So contractor also have two options, which is first option is to request for the affected part to be omitted from site. If the SO agree, it become variation, as well as the contractor must continue the works and cannot terminate the contract. Then if the SO does not agree, the contractor can proceed with the works when the portion of the site is made available. He also can claim for the loss and damage, as well as cannot terminate the contract. The second option is agree to proceed with the work when the relevant portion of site is made available. The contractor is not eligible for loss and damage due to the delay possession of site, as well as he cannot terminate the contract.
Next, we have contractor obligation after site possession. Contractor need to start the works and complete the works on or before the date of completion as stated in appendix. It is an obligation contractor to proceed with the work regularly and diligently and complete the work time. The requirement ensure that the contractor will perform according to the agreed schedule and the project can be complete within the promise. This is mean as soon as the site position be given, it is main responsibility for the contractor to start and finish the project on the date stated or before the completion date. Contractor also must work with passion by follow the rules to make sure that the contractor work according to the schedule that being agreed, and the project must complete based on the time given. Next is the superintendent officer will give written form to the contractor specified, such as default and requiring the contractor to remedy, such as default within 14 days of the receipt of the default notice or any period determined by officer name in appendix. The events of the default is based on clause 51.1a. Contractor fails to commence work within 2 weeks after the date of site possession and fails to proceed regularly and diligently with performance of his obligation of contract. As a result, the good contractor obligation could give good effect to construction work progress nowadays.
In PEM contract, the matter involved in commencement, postponement and completion date by refer to the clause 21.1. The contractor must be given full possession of site, which is the whole site, even some part may not be needed until a later stage of the project. The contractor also has the right to free access to the whole site in order to properly plan his work unless there is agreement to the contrary. The architect will issue instructions to fix the date for site position. If the date of commencement is not specified or the date specified become invalidated, which is not due to the contractor's fault. For example, when the deferment of position of site by the employer to a new date, the architect has the power to defer the position of site for any reason. If the date of position is deferred, the completion will also be revised accordingly.
Next, we will go through about construction insurance and bonds. Firstly, we will go through about the definition. The definition is insurance is a contract by which one party, the insurer, in exchange for consideration, for example, money or a premium, promises to make payments upon the destruction or injury of something in which the other party, the insured, has an interest. This is mean the insurance become a saver between two parties. If any risks happen, then the insurance will cover by money. The insurer agrees to give the insured some benefits, usually financial compensation. Financial compensation is like indemnity or damage if a specified event occurs. The event must involve some uncertainty about whether or when it will happen, which means we will get money of the damage happens, so we don't need to worry of the financial burden if anything happens.
Why insurance is important? As it involves high-risk work, such as construction work, so insurance acts as a party that can alleviate the financial burden in the event of any claims from any party in the contract during the construction project.
Okay, next slide is salient features of an insurance contract. Salient means of important. Okay, so what is the important for insurance contract? First, the premium is payable. The amount of taxation, any additional fees payable, how long the quotation is valid for, the name of the insurance company, the key facts document outlining all the salient information pertaining to the insurance. This is also mean premium is an amount that need to pay periodically by the contractor to the insurer in order to cover his risk. In this insurance contract, the risk from the contractor is transferred to the insurer. So, in taking this risk, the insurer charge an amount to the contractor which called as premium. Next is the type of insurance. Okay, there is 5 types of insurance, which is the first is all risk insurance. Next is professional indemnity insurance. Next is product liability insurance, public liability insurance, and last one is latent defects insurance.
Next, all risk insurance is an insurance that covers all types of engineering civil works. If there is any accidental loss or damage to the works, including the contractor's plant and equipment, as well as third-party personal damage, it can be claimed under these types of insurance, which is all risk insurance. So, these types of insurance is important because it can cover everything. Professional indemnity insurance insures against liability arising from professional negligence. Indemnity means protection, while negligence means failure to take over something. If there is negligence committed by professionals such as design failure, so this insurance will cover the loss. Architect, engineer, others professionals, consultant, and a building contractor that owns a design responsibility to its employers are usually required to maintain such insurance. Other than that, public liability insurance. This policy, the insured in respect of his legal liability for body injury to third parties like members of the public, visitors, trespassers, subcontractor, as well as who may be physically injured or whose property may be damaged or goods. The policy are, however, concerned only with physical damage to material only, and injury or damage causes accidentally. Thus, if the insured caused the injury deliberately, he will not be entitled to claim under this policy.
Next is product liability insurance. Product liability insurance protects against liability for injury to people or damage to property arising out of products supplied by businesses or suppliers of equipment to a construction or engineering project such as lift or escalator may be required to maintain such insurance and sometimes in place of professional indemnity insurance. This means if anything happened to a product such as the damages, the insurance will cover it. And for example, for engineering projects such as lift or escalator or any equipment for construction project.
Next slide is latent defects insurance. Okay, latent defects insurance is also known as decennial insurance. Okay, latent defect also means hidden defect in material. This is also can be mean which the defects will often occur suddenly where during the process of making the work, the defect for some of particular material cannot be detected. This is because why we call the latent defect as a hidden defect of the material. It is also always happen after all of the construction works is already done and complete. Okay, for example, when all the construction works is complete, the defect in the material, in the certain material, cannot be detected, and it is also cannot be known whether the defect is present or not. So this thing will be under the latent defects insurance. Next is latent defects insurance also typically protects the owner against the cost of remedying the structure of building due to a defect. This is also can be mean which is this insurance under this insurance can protect the owner from not spending any money, from not spending too much money or spending the high cost for the maintenance works due to the defects in certain material. And it is also usually it lasts for 10 years from the original construction for a building, and it is also typically for a building owner is must to arrange the cover in advance.
Now we're gonna explain about performance bond. If a contractor default, the surety is obligated to complete the project up to the original value plus the value of any change orders that were approved by the surety. First of all, about the performance bond, there will be bail money that issued by authorized party of nation government, and the one who issued the bond is approved financial institution of Malaysia. Moreover, only financial company that has been registered can buy the bond, which is the contractor. The amount of the bond is basically 5% of the contract sum. Then, the purpose of contractor buying the bond and give it to the client is to prove the client that the contractor really committed to complete the project, and the bond will be buy before the project started, which is 5% from the contract sum. If the contractor could not afford to buy the performance bond, there has another way, which is second option, which called performance guarantee sum (PGS). In Malay we call as wang jaminan pelaksanaan. The aim and concept for this method is actually similar to performance bonds. The difference is every payment per month will be less for 10% until the amount of payment become 5% overall. Same as performance bond, instead of pay lump sum, the amount will be deduct 10% from every payment. The client also will keep the 5% money or hold a trust of the money for the use if anything's happened. The example for the default are, the contractor did not want to make good of damage that happened that caused by them. So here's where the client used the 5% of performance bond to pay other contractor to make good the damage that the main contractor does not want to, and this is why the client will keep the 5% of performance bond. Finally, for this performance bonds topic, there will be 2 stages to give the performance bonds back to the contractor. When the CPC, Certificate of Practical Completion, be taken out, which means the project is already complete, the 2.5% from 5% will be given to the main con, and the other 2.5% from 5% performance bonds will be given when the contractor already made good their work, such as the damage.
So that's all from us, and we hope you can learn more about the site possession and insurance bonds. Thank you everyone and have a good day.